supposed to do?
I ain't paying nothing to nobody. What I'm supposed to do? I'm trying to take care of my nieces and nephews, running back and forth to the store and stuff. What I'm supposed to do? What you want me to do?
If you need things, we can.
All I'm doing is the best I can. I'm not doing anything to nobody. What you want me to do? I didn't have nothing to do with that.
Mr. Ladon, you are on bond for a terroristic threat. You've now picked up a criminal mischief. You are facing up to 6 months in jail and or a $2,000 fine.
Whoa, rewind that. Did you catch that? Our guy is already out on bond for a terroristic threat, and now he's got another charge? Let's just say, the courtroom patience meter is running on fumes. This is no longer just a family man running errands.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 11th, 2025, the officer responded to a physical disturbance at a residence in Harris County, Texas.
A green stuffed animal, with a kitchen knife hidden inside? That's either MacGyver level planning or a cry for help disguised in plush. Either way, the legal stakes just got upgraded from quirky to concerning. What do you think? Weapon smuggling or coincidence?
Dispatch advised that the caller was reporting he had a knife and was going to stab someone because they were bothering him about a broken window. The officer made contact with the defendant and the complainant, and the defendant stated he called the officer. The defendant was found to be in possession of a green stuffed animal which had a fixed blade kitchen knife concealed inside. The defendant stated the complainant came to his house with her roommate accusing him of breaking a window at her apartment.
Whoa, you're going really fast.
Yes, Judge.
The defendant.
Called the officer.
Okay.
He said that the complainant had come to his house with her roommate, accusing him of breaking a window at her apartment. The defendant stated he was walking back to his apartment and that the complainant came out the back door to her apartment, but then he changed the story saying that she came out the front door to her apartment to confront him. The complainant stated that the defendant stated that the complainant came with a gun, though he did not see the gun. The complainant stated that she was laying in bed, heard a glass window in the back door break, jumped up, ran to the back door, and saw the defendant walking away from the door, holding a green stuffed animal with a knife. Apartment management stated the cost to repair the window was $200.
There's a lot of randomness in it, Judge.
The only thing my concern is who broke the window? Did he break the window?
And Your Honor, so according to the DMs, what the complainant says is that she saw him walking away. She heard the broken window. She came downstairs and saw him walking away. And then that's what we have in the DMs. And then I spoke with her yesterday as well. And she repeated the same thing, that he was the only one there when the window was broken. And that's what she said. She saw him outside the window door when it was broken.
He's walking away. He actually calls the police because he's being harassed by this woman because she's...
This right here is courtroom fog. We've got a shattered window, no eyewitness to the actual break, and shifting stories. It's like everyone saw a different episode of the same show. Legally speaking, that's called reasonable doubt, folks.
Saying that he broke a window. And I don't think there's any list of physical evidence like glass on him or anything, or in the whatever stuffed animal.
At what point did the cops come and did they arrest him on the spot? What, do we have any other physical evidence? Do they?
We have the two further just complaints said that he was approximately 20 feet away from the back door when she saw him, and that the officer found the window to be shattered. And then the complainant showed the back door to her apartment.
I mean, how do we know he did it?
No one's saying that he did.
I mean, no one saw, you know? It's...
To be honest, just what we have is that the window was broken, and then she saw him outside at the time when she came downstairs to check on it. That's what we have.
I get it. I get it. I don't think it's enough. However, the fact is, we're still having issues with the same complaining witness. I now have to take more drastic action to ensure.
Notice that shift. The judge just put down the velvet gavel and picked up the hammer. The message is clear. No weapons means no weapons. One more slip, and it's go directly to jail. Do not pass go. Do you think that's fair, given the mental health concerns coming up?
Nothing happens in the future. So now what I'm going to do is I'm putting an ankle monitor on it, and I'm barring him from going within 500 feet of where she lives or where she works.
Yes, Judge. Ankle monitor, just want to make sure it's ELM and not scram.
Correct.
Okay. Acid fees be waived? Okay. I'll add.
How far do they live from each other, Alex? You know?
Do you think those are complex?
It was described as across the street. But when I spoke to the complainant, she said that they do not live across the street, that he was staying at a friend's house, but he told officers that she lives across the street.
So what I'm doing, Mr. Franklin, is I'm going to put a monitor on your ankle, and there is a radius of where you cannot go where this person lives or works. And I mean, we may have issues with bond conditions as it is, because if I ordered him not to have weapons on the terroristic threat and they show me that, or they prove to me that you have weapons, I'm going to put your butt in jail. So maybe we should have a formal bond hearing to see if, in fact, you can prove that he has a weapon.
So I have some hesitancy about everything, Judge, mostly because my client's orange sheet is quite extensive. So the jail has diagnosed multiple mental illnesses. I'm trying to track down his competency because I was appointed, I think, December. So there's been prior competency motions. I'm trying to get the reports from them, which is difficult because I forget what agency does them.
And just when you thought this couldn't get more intense, bam! Now the knife possession could violate bond even if no crime was committed. That's the tightrope of conditional freedom. The rules are the rules, and breaking them, even accidentally, can cost you your liberty.
Health evaluations. They're saying that they don't exist, so I'm trying to find his mental health records, Judge. It sounds to me like it's bipolar schizophrenia or schizoaffective. And so I think that my client is likely going to have severe mental health issues, which have been causing issues. And I think that's going to be the heart of all this. And so I'm trying to push for treatment. The case is just brand new is the problem.
You were ordered not to be in possession of any weapons. And they're telling me now that you have a new case and that you have an alleged knife as well. I want to set this for a formal hearing on Monday. And if they show me that you have a weapon in violation of your bond conditions, I'm going to bring it. Do you understand? You are not to be in possession of any weapons whatsoever. Get a hold of your witnesses.
Yes, sir.
Get a hold of the cop.
Yeah.
Let's have a formal hearing on Monday to show me whether he's in possession of a weapon or not.
Yes, Judge.
Yes, Judge.
In the meantime, like I said, if I find that you become a danger to my community, it's really not going to go well for you. Do you understand, Mr. Franklin? There is no excuse. You will get this ankle monitor today, and you're not to go within 500 feet of where this complaining witness lives or works.
If I can politely ask, Judge, that we reset for more than Monday, only because this case is new enough that there's literally no offense report. So I don't know officers' names or.
Case.
So the new case, the criminal mischief, which will be the allegation for the motion for.
Find no probable cause in a criminal mischief.
Well, but the problem is, Your Honor, is that it's on the criminal mischief that we have the officer that saw the alleged knife. So we'd have to get in contact. We don't have the OR. We have the name. I could reach out, but we don't have the OR to give defense. So that way they can review it. And
So the allegation is, and it's we don't have an OR, so we're reading DIMS. So the allegation sounds like the officer saw a knife, or maybe the CW saw a knife. It's unclear.
To me, it sounded like both saw a knife. And so that's why.
I don't know
So,
if
I
anybody
mean,
did.
I guess I'll give you a full week. You know, that should be sufficient for you to get an OR,
Yes,
get in
yes,
contact
yes,
with both
because-
witnesses.
just to clarify for both parties here, the officer is the one that said when he contacted him, he found the defendant in possession of the knife.
Okay, let's have a hearing.
Yes, Judge.
Get this guy over here. If you need to subpoena him, do it. So that today's Wednesday, we'll have a hearing next Wednesday.
Thank you, Judge.
All right.
1 week later.
So we were here for one bond violation report, which I don't think that one actually got filed. I think you had just requested it. He had picked up a new case, you no PC'd, state dismissed, but the new case involved him possessing, though not using, a kitchen knife. And so the bond conditions.
I didn't ding him on it, did I?
Well, you had asked us to come back today to address the fact that he had.
Oh, right.
Kitchen
That he
knife.
had the knife. Correct.
Yeah, so not that he had potentially committed a crime, but that he had a kitchen knife when he was ordered not to have a weapon.
I need your help. Come up, Mr. Ladon. The initial reason that we were here today was because of the case that you picked up that I found no probable cause and that I had an issue because they were alleging that a knife was, I guess, allegedly in possession or whatnot.
If the allegation is possession, there was no allegations of use or threat. It's just that he had a kitchen knife on him.
You are on bond for a
There's threat.
terroristic threat. As part of your bond condition, you had several. You're not to be in possession of any weapons. You have a GPS monitor, and you're not to go within a certain boundary of the complaining witness in this case. It has now come to my attention through pretrial services that you have bond violations. Mr. Franklin has not been compliant with his conditions of bond. Client has failed to not have contact with a prohibited person or visiting a restricted location. Client was ordered by the court not to go within 500 feet of the Northwood Drive apartment in Baytown. On 2/25, client received a victim exclusion zone alert.
14 exclusion zone pings in 6 minutes? That's a record-breaking speed run into trouble. But here's the kicker. There's no evidence of direct contact with the victim. So is this a serious breach or just a GPS glitch with high-stakes consequences?
At 10:22 a.m. The victim exclusion zone was cleared at 10:28 a.m. In fact, what I've been told by pretrial is that we have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 instant.
Okay, interject, Judge. I think that's all in a 6-minute window. So I think he crossed into the exclusion zone at 10:22 and out at 10:28. And so I could proffer to the court what was given to me from pretrial. Not that I'm admitting.
Judge has a copy.
Then never mind.
I get it.
In no way admitting that this would be admissible. And looking at what pretrial has provided, it looks like he walked about 1,000, maybe 1,500 feet in about a 6-minute window through the exclusion zone. And while it says contact, there's no alleged contact with any person. It's just, I know, but it's the way it's written.
How do we know?
Well, no one has complained to the state. And so it looks like he walked through an exclusion zone, which is, speaking with pretrial, is actually larger than it normally is. I think it's at 500. Is it 500 feet?
At 500 feet because I didn't want him to go anywhere near the complaining witness in this case.
Yes, Judge.
This is the same complaining witness that we have the last case that I know PC'd.
No, the two are unrelated.
They are different complainants, Judge.
Yes. And so the terroristic threat was, they're both strangers. The terroristic threat is, the allegation is that my client asked to bum a cigarette, got in an argument when he got it. And then the newer case with no PC was that some random person's window was broken and somehow my client got charged with it when no one saw or had any evidence to believe he had done it. But when the police made scene, he didn't have a kitchen knife, I believe, is the allegation. I will say that the new case, it was no PC, but there's also no evidence. There's no offense report. There's no videos because it's a week old.
Because it's because they didn't go and get anything because I know PC'd it.
Well, that's part of it. It's also Baytown and Baytown.
But the problem is that we continue to have issues with Mr. Franklin.
So Mr. Franklin is going to have issues on bond or not, Your Honor. His mental illness is quite severe. He's received hospitalizations in the past. His orange sheet is right at a page, if not over. And so the system is aware. I would take this court or ask this court to take caution in the sense that we're not having a formal hearing. There's no testimony presented. I'm fine with having a conversation. But if the court should wish to revoke
We're
his
having
bond,
a hearing right now.
well, then nothing has been admitted because there was no admissible evidence. I'll find to discuss with the court what has been alleged, but there is no admissible evidence of either location or possession because nobody has testified to either. And I don't think the pretrial services officer in this room would have the ability to testify how a GPS device works. Not to be mean to her, but it's not her job. And so she's not going to have any knowledge of the firsthand knowledge of the device.
We continue to have issues with Mr. Franklin, and I'm tired of it. I'm not dealing with this anymore. I only have one way to fix this.
So I've spoken with the state, particularly the chief. We're leaning towards reaching a resolution on a mental health diversion, Judge.